Mr. Louis Ahearne and Mr. Stewart Ahearne, you can remain seated for the moment. The victim surcharge will apply in this case to each of these defendants, and I direct that the order be drawn up in the appropriate amount after the hearing. Daniel Kelly is not present in court today. I accept that he wished to be present, but he is prevented from attending by severe back pain. His counsel, Miss Jones, has confirmed that instructions have been taken from him, and she's content that I proceed to sentence him in his absence. And so that is what I will do. On Monday, the 24th of March of 2025, Daniel Kelly, Louis Ahearne and Stewart Ahearne were all found guilty of conspiracy to murder Paul Allen. The verdicts were unanimous decisions by the jury. On the 11th of July of 2019, at just after 11 o'clock at night, a number of shots were fired through the ground floor windows at the back of Paul Allen's home. Mr. Allen was hit by 2 of the bullets. He survived the shooting, but he suffered life-changing injuries. 1 bullet caused wounds to the thumb and little finger on his left hand. Another bullet entered on a downwards trajectory at the front of his neck and lodged in his spinal cord, leaving him paralysed for life. Daniel Kelly and Louis Ahearne were there at the back of Paul Allen's house that night. I'm satisfied that Stewart Ahearne was not present that night. You, Louis Ahearne, were the only defendant to give evidence at the trial. You accepted that you were there at the back of Paul Allen's house, but you said that you had no idea that a shooting was planned. You said you thought that you and Daniel Kelly were carrying out a reconnaissance for a burglary. The jury rejected that account. Neither Daniel Kelly nor Stewart Ahearne gave evidence. The case put forward on behalf of each of them was that he was not present at the scene of the shooting and he wasn't part of any agreement to murder Paul Allen. Paul Allen lived with his partner, Jade Bovingdon, and their 2 very young children. Mr. Allen was convicted in 2006 for taking part in an armed robbery and was sentenced to 18 years imprisonment. Whether the motive for this shooting was connected with that is something we do not and may never know. The 3 defendants in this case worked together to carry out burglaries. On the 1st of June of 2019, they burgled a museum in Geneva and managed to steal 3 items, including a Ming vase with a combined value of more than £3 million. Louis Ahearne's evidence at this trial was that he became involved in this in order to pay back a large debt that he owed to Mr. Kelly. I have read the full judgment of the Swiss court, and I heard Louis Ahearne's account. And I'm satisfied that Mr. Kelly recruited the Ahearne brothers to that enterprise. On the 27th of June of 2019, there was a reconnaissance expedition to the area where Paul Allen lived. A Mercedes with a registration number starting LL66 was used for that expedition. Daniel Kelly was the only person insured to drive that car, and it was he who paid for the insurance. I'm satisfied that Mr. Kelly was in the car on that day. I can't be sure that Louis Ahearne and Stewart Ahearne were with him. On the night of the 7th of July of 2019, there was another reconnaissance expedition. Daniel Kelly's telephone was activating cells in the vicinity of Paul Allen's address at 11 o'clock until just after midnight. His telephone SIM card was also switched between his telephone handset and an iPad in the course of that night. The iPad was used in the planning and carrying out of the shooting. Once again, I cannot be sure that either of the Ahearne brothers was present on that night. On the 9th of July of 2019, Stewart Ahearne hired a Renault Captur from Avis in Dartford. He hired it in his own name and presented his own driving licence. The Renault was later to be used in the shooting of Paul Allen. However, on that night, the 9th of July, the 3 of you went in the Renault Captur with a 4th man to a gated community in Kent. You were disguised as police officers with a flashing light attached to the car. You burgled 1 apartment and attempted to burgle another. On the next morning, the 10th of July of 2019, a telephone number ending 7391 made its first appearance. This was a number used for making the arrangements for and carrying out the shooting. Its first activity was a text to you, Stewart Ahearne, at 23 minutes past 9 that morning. The text read, "Yo, Mackerel, call on this." Over the 3 days that this 7391 phone number was in use, it was only ever in contact with 7 numbers. The most frequent contact was with Stewart Ahearne's number 9636. The second highest contact number was one attributed to Daniel Kelly's partner. One of the other 5 numbers it was in contact with was Louis Ahearne's partner. Another of the contacts from that telephone was a man called Sean Skinner, who is currently serving a lengthy sentence for drug and firearms offences. That is one of the indications of Daniel Kelly's associates. Later that afternoon, on the 10th of July, the Renault Captur trailed a Mercedes registration AF18, which was owned by Paul Allen and Jade Bovingdon, his partner. Miss Bovingdon was driving it that day. I'm satisfied that one or more of you or your associates placed a tracker under that Mercedes at some stage, since it would otherwise have been impossible to find the car and to track it on that afternoon. The evidence showed that Daniel Kelly had obtained several trackers. Louis Ahearne accepted in his evidence that he was in the Renault Captur that afternoon and said that he was with his brother Stewart, who was driving, and with Daniel Kelly. Louis Ahearne said that he thought they were going back to Kent in connection with another burglary. The Renault Captur was due to be returned to the car hire company the next day, the 11th of July, but the company simply extended the rental by 1 day and notified Stewart Ahearne by text message that they had done so. And so we come to the 11th of July, the day of the shooting of Paul Allen. And on that morning, the same Mercedes as had been used in the 27th of June reconnaissance trip was again driven from the Woolwich area, this time at about 5:30 in the morning, to the area of Paul Allen's home address in the north. The iPad, which had been used late on the night of the 7th of July with Daniel Kelly's SIM card inside it, was also being used. That car returned to the Woolwich area at about 7:15 that morning. In the evening, Daniel Kelly and Louis Ahearne went in the Renault Captur to Paul Allen's home address. Louis Ahearne's account was that he thought they were going to carry out another burglary. He told the jury that they stopped on the way and he bought plastic gloves and tape at Daniel Kelly's request. They also stole registration plates from a van and put them onto the Renault. Paul Allen was not present at home when Daniel Kelly and Louis Ahearne first arrived in the area, but he returned home later. It was while he was in his kitchen about 11 o'clock that night that shots were fired from the back of his garden and into his house. The firearm was never recovered, but the expert evidence was that a Glock pistol was used in the shooting. I'm satisfied that the shots were fired by Daniel Kelly. He could be seen on the CCTV footage that night, just before the shooting, putting on a pair of gloves, and, in addition, an accessory, a modular optical sight, which can be used on a Glock pistol to improve accuracy, was later found at his home address. At least 6 bullets were fired, and 2 of them struck Mr. Allen. On the way back to the Woolwich area after the shooting, Daniel Kelly threw the iPad that had been used in connection with the shooting into the River Thames. Remarkably, it was found in a search by police divers in November of 2024, and data was recovered from it. The Mercedes LL66 that had been used in the reconnaissance expeditions was sold in Peterborough on the 15th of July of 2019 in part exchange for an Audi. Daniel Kelly and his partner, together with a man called Mbaki Nkwa, were present. And on the 15th of August of 2019, the Audi was stopped by the police for an unrelated reason. Daniel Kelly and Louis Ahearne were in the car with 2 others, and 2 tracking devices were found. Stewart Ahearne was arrested and then interviewed on the 30th of October of 2019. Louis Ahearne was arrested in December of 2019, and Daniel Kelly in January of 2020. The reason for the delay in bringing the case to trial was that Louis Ahearne and Stewart Ahearne were extradited to Switzerland, where they stood trial for the burglary of the museum in Geneva. They were convicted and sentenced to terms of imprisonment. Stewart and Louis Ahearne returned to the United Kingdom in March and June 2024, respectively, and were charged with the matter for which they fall to be sentenced today. Daniel Kelly did not return to Switzerland for trial with them, and I'm told the reason was that there is a competing extradition request in relation to an alleged robbery in Japan in relation to Daniel Kelly. Both of those extradition requests, as I understand it, from Switzerland and Japan remain outstanding. There are no victim impact statements before the court, but Paul Allen's injuries were severe. One bullet caused wounds to the thumb and little finger of his left hand. Another bullet entered on a downwards trajectory at the front of Mr. Allen's neck and lodged in his spinal cord, leaving him permanently paraplegic. That is, he has lost movement and feeling to the majority of the trunk of his body and all of his legs. Injuries of this type remain life-threatening because they carry additional medical and physiological consequences, including loss of normal regulation of blood pressure, which can rise suddenly and precipitously to dangerous levels. Paul Allen will be dependent on others for all of his needs for the rest of his life. I now turn to the role and the culpability of each one of you. You all denied participating in any conspiracy at all, but that does not prevent me from forming a view as to the respective roles of each of you. In the course of the trial, I have become familiar with the many and intricate pieces of evidence, and I had the benefit of hearing Louis Ahearne's account. I've been able to come to a clear and sure conclusion as to the role played by each of you and to your individual culpability. My conclusions are as follows. The underlying motive for the shooting, on the part of those who instigated it, remains unknown. I have no doubt that this agreement to murder Paul Allen involved other people, apart from the three of you, and that you three were motivated by a promise of financial gain. I am satisfied that Daniel Kelly, while not the instigator, was higher up in the organisational chain than Louis Ahearne or Stewart Ahearne. It was Daniel Kelly who recruited Louis Ahearne and Stewart Ahearne. Daniel Kelly went to some lengths to avoid detection and to conceal his own involvement. Daniel Kelly carried out the reconnaissance trips and arranged for a tracker or trackers to be placed on Paul Allen's Mercedes. While no tracker was found after the car was seized, that the car could not have been found and followed on the afternoon of the 10th of July if it had not been tracked. I'm also satisfied that it was Daniel Kelly who fired the shots through the Allen family windows. Louis Ahearne was the getaway driver and was present as a backup. He also, by his own admission, bought gloves and tape and assisted in placing stolen registration plates on the Renault Captur on the night of the shooting. He was also present when the Allen household Mercedes was followed on the 10th of July. Stewart Ahearne's principal role was to hire the Renault Captur, which was to be used by those carrying out the shooting, and he otherwise provided logistical support. He hired the car in his own name, using his own details. He also retained the mobile phone he used at the time. This indicates a lack of sophistication on his part. He too was present when the Allen household Mercedes was followed on the 10th of July. I turn then to the defendants and their antecedents. Daniel Kelly was born on the 26th of October of 1978 and is now 46 years of age. Mr. Kelly has 20 convictions for 60 offences. These started with shoplifting at the age of 11, and at the age of 12 he was fined for carrying an air weapon and a bladed article in a public place. At the age of 15, Mr. Kelly was convicted of 3 offences of robbery and for carrying a firearm with intent to commit an indictable offence. At the age of 20, he received a sentence of 45 months' imprisonment for being concerned in the supply of Class A drugs. Other offences include several for dwelling house burglaries and, in 2004, an aggravated burglary and kidnapping. The most recent was a conviction for the importation of Class A drugs, for which Mr. Kelly was sentenced to 6 years' imprisonment on the 12th of January of 2022 in the Crown Court sitting at Snaresbrook. There are currently extradition requests from Switzerland and from Japan in relation to other alleged offences. Louis Ahearne was born on the 2nd of December of 1988 and is now 36 years of age. Louis Ahearne has 6 convictions for 14 offences. These include 2 dwelling house burglaries in 2019 and the burglary of very high-value items from the museum in Geneva. In 2020, he was sentenced to 12 months' imprisonment for possessing a prohibited weapon, namely a stun gun, which was a small taser. Louis Ahearne has no convictions for offences of violence. Stewart Ahearne was born on the 21st of August of 1978 and is Louis's older brother. He is now 46 years of age. Stewart Ahearne has 9 convictions for 26 offences. These include the supply of Class A drugs and an offence of wounding with intent to cause grievous bodily harm, for which he was sentenced to 40 months' imprisonment in 2007. He has no other convictions for offences of violence apart from a minor public order offence in 2019, for which he received a fine. There are no sentencing guidelines for conspiracy to murder, but all parties agree that the sentencing guidelines for attempted murder can be considered. Section 63 of the Sentencing Act reflects the need for me to consider both culpability and harm, both caused and intended, when assessing the seriousness of any offence. I must first consider the offence category. The culpability of each one of you is very high because of the use of a firearm and because the offence was committed for financial gain. The harm caused to the victim was very serious. Indeed, short of killing him, it could hardly be more serious. He is permanently paralysed and reliant on others for every single need. The offence category, therefore, is A1 under the attempted murder guideline. The starting point is 35 years imprisonment and the range is 30 to 40 years. The aggravating factors are previous convictions in the case of Daniel Kelly. He has previous convictions for violence and for carrying firearms. I bear in mind, however, that the last of this category of convictions was in 2004, when he was convicted of aggravated burglary. Since then, his criminality has consisted largely of dwelling house burglaries and the importation of drugs. Second, the shooting was carried out in circumstances where others, including 2 young children, were put at risk. While Louis and Stewart Ahearne may not have known that children would be present, any plan to fire shots into a dwelling house late at night is bound to carry such a risk. Daniel Kelly attempted to destroy the iPad used in the commission of the offence by throwing it into the River Thames, and he was a party to concealing the Mercedes LL66 used in the reconnaissance trips by selling it in Peterborough after the shooting. I do not treat the previous convictions of Louis Ahearne or Stewart Ahearne as significant aggravating factors. Louis Ahearne has no convictions for offences of violence. He does have a conviction for the possession of a stun gun, but it was a small taser, and that is an offence of a wholly different nature from the use of a Glock pistol to shoot. Stewart Ahearne has a conviction for causing grievous bodily harm with intent, but it was in 2007. I turn to the mitigating factors. Miss Jones, who appears on behalf of Mr. Kelly, has realistically accepted, and I'm told on his instructions, that there is nothing that can be advanced by way of mitigation. As far as Louis Ahearne is concerned, I have read a great many positive reports from His Majesty's Prison Wandsworth about Louis Ahearne's activities there, and I've also read a letter from Louis Ahearne himself. I have taken account of all of this material. It is of limited weight when set against the gravity of the offence, but it is a part of the information before me which has been of assistance in my assessment of whether Louis Ahearne meets the criteria for a finding that he meets the statutory definition of dangerousness. Mr. Chowdhury, who appears on behalf of Louis Ahearne, draws my attention in addition to the length of time that has passed since this incident and the time that Louis Ahearne has spent in prison in Switzerland before being extradited back to stand trial on this matter. Mr. Woods, who appears on behalf of Stewart Ahearne, also draws my attention to the length of time that has passed since this incident and the time that Stewart Ahearne has also spent in prison in Switzerland before being extradited back to stand trial on this matter. I've also read a great many positive reports from His Majesty's Prison Wandsworth about Stewart Ahearne's activities there. I have taken account of all of this material. As in the case of his brother, the material is of limited weight when set against the gravity of the offence, but it is part of the information before me which has been of assistance in my assessment of whether Stewart Ahearne meets the criteria for a finding that he meets the statutory definition of dangerousness, to which I now turn. The issue of dangerousness is governed by Section 308 of the Sentencing Act, and I must decide, taking into account a number of factors, whether one or more of these defendants poses a significant risk of serious harm to members of the public occasioned by the commission of further specified offences. If I conclude that one or more of the defendants does pose such a risk, I must then consider what the appropriate sentence is. I did not ask for pre-sentence reports to assist with the assessment of dangerousness because I have a wealth of detailed information which would not be readily available to a probation officer. I had the benefit of observing the defendants during the course of the trial. I have detailed knowledge of the communications adduced at the trial between them and other parties. I heard bad character applications, and I've had sight of the underlying evidence in relation to some of the defendants' previous convictions and in relation to other conduct. I also know something about those associated with Daniel Kelly, in particular, because they featured in the trial. I've mentioned Mr. Skinner. Another was Mr. Mbaki Nkwa, the registered owner of the Mercedes LL66 reconnaissance car. He was present when the Renault was hired and when the Mercedes reconnaissance car was sold. His email address was registered on the account with the company who supplied trackers to Daniel Kelly. Mr. Nkwa has an extensive criminal record, which includes drug and firearm-related convictions. In addition, I have received, to all that information before me, I have also received the additional information in preparation from this hearing, and in particular the very large number of reports from Wandsworth Prison to which I have referred. I'm not satisfied that Louis Ahearne presents a continuing and significant risk of serious harm to the public, taking all matters into account. This conclusion is based upon the impression I formed in the course of his evidence, his antecedent history, and the material made available since the trial about his activities while in custody. These present positive evidence that in the 6 years since this offence was committed, Louis Ahearne has changed his approach to criminality. Reports of positive progress in custody must be approached with a degree of scepticism, but Louis Ahearne has amassed several reports from prison officers and others confirming his sustained efforts to contribute in a positive way to prison life and to support others, including those with neurodiverse conditions. I'm also not satisfied that Stewart Ahearne presents a continuing and significant risk of serious harm to the public. This conclusion is based upon his limited role in the conspiracy, his antecedent history, and the material made available since the trial about his activities while in custody, which, as in the case of his brother, demonstrate a willingness to change. I repeat that reports of positive progress in custody must be approached with a degree of scepticism, but Stewart Ahearne has attracted impressive commendations from a wide range of others, attesting to his contribution to the well-being of others and his consistent support for the vulnerable, and in particular those with neurodiverse conditions. I've given careful consideration to Daniel Kelly. He was more closely involved with those who instigated this shooting of Paul Allen, and he did play a significant role in the planning and execution of the shooting, and in the attempt to conceal the Mercedes and the iPad and the firearm, which has never been recovered. I've concluded that Daniel Kelly is a dangerous offender. There is a significant risk of him causing serious harm in the future by committing a specified offence. That conclusion is based upon the facts of this offence, the role he played, all that I know about his association with other criminals, and his antecedent history. I turn then to sentence. Daniel Kelly is not present. I've concluded that he is a dangerous offender, and I must now decide if a life sentence is justified after considering the seriousness of the offence, his previous convictions, the level of danger he represents to the public and for how long, and the available alternative sentences. This was a very serious offence, but it is not difficult to envisage examples of conspiracies to murder of even greater gravity. A life sentence is a sentence of last resort, and there are alternative sentences available to provide the protection that the public require. These are an extended determinate sentence or a very long determinate sentence. I've concluded that a life sentence is not justified. I have also concluded that a determinate sentence does not sufficiently address the risk that Mr. Kelly presents, and so there will be an extended sentence of imprisonment. Mr. Kelly will serve at least 2/3 of the determinate sentence that I pass. After that, the parole board will consider what continuing risk he poses to the public. He may not be released until he has served the full term. Whenever he is released, he will be subject to licence conditions for any unserved part of the custodial term, plus a further 5 years. If, when subject to licence, Mr. Kelly commits another offence or fails to comply with the terms of his release, he is liable to be recalled to custody and may serve the entire sentence in custody. The total sentence I pass will be an extended sentence of 41 years, which is a custodial term of 36 years, plus an extension period of 5 years. Louis Ahearne, will you stand up, please? I'm satisfied that in your case a determinate sentence is appropriate, and any time that you've spent on remand in relation to this offence will be deducted administratively. You will be released from custody no later than 2/3 of the way through the sentence, and the remainder of the sentence will be served on licence in the community. You must comply with all the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the term in custody. The sentence I pass is a determinate sentence of 33 years imprisonment. You may sit down. Stewart Ahearne, I'm satisfied that in your case a long determinate sentence is appropriate. Any time that you've spent on remand in relation to this offence will be deducted administratively. You will be released from custody no later than 2/3 of the way through the sentence, and the remainder of the sentence will be served on licence in the community. You must comply with all the conditions of your licence, failing which you will be at risk of recall to prison to serve the remainder of the term in custody. The sentence I pass is one of 30 years imprisonment. You may also be seated, and the defendants may go down.
Each of them. And this is a case really where those three men we can see on the screen were found guilty of plotting to kill a member of the Securitas heist gang. And last month they were found guilty of conspiring to kill Paul Allen, who was actually convicted of Britain's largest cash robbery back in 2006. There is actually one of the defendants buying drinks before the event took place. 36-year-old Louis Ahearne, his brother Stewart Ahearne, 46, and Daniel Kelly, also 46, shot Paul Allen back in 2019. He was then paralysed for life. He was shot through his kitchen window. The glass shattered while standing in his kitchen in his home in northeast London. And now today, Louis Ahearne faces a sentence of 33 years. Stewart Ahearne faces a sentence of 30 years. And Daniel Kelly faces 41 years. And the judge, Sarah Whitehouse KC, had said that the shots were fired by Daniel Kelly, who has numerous previous convictions. She said he's a dangerous offender, but the underlying motivation for the shooting is still unclear. And that brings me to some of the discussion by prosecutors during the trial itself. During the trial itself, there was no motive suggested for the shooting, but prosecutors had alleged that Allen was what they called a sophisticated career criminal, and he was actually convicted of Britain's biggest armed robbery at a Securitas depot in Kent in 2006. And this was a depot that held vast amounts of cash that was going to be distributed to banks and also to cash machines. And in this, Allen and others stole £54 million in cash. Much of that has still never actually been recovered. He was released from prison in 2019. He'd served an 18-year sentence. That's Paul Allen. But of course, then he was shot by the trio in his home that year. And the court through the trial had heard how the defendants, who we can see on the screen, carefully planned this shooting. They undertook surveillance of their victim. They attached a tracker to the victim's car, and police found bullet casings in Paul Allen's garden and DNA evidence linking the three of them to the scene. And the three that we can see on screen are fundamentally experienced international criminals. And actually, just a month before Paul Allen was shot, they undertook a robbery of a museum, an arts museum in Switzerland, where they stole Ming Dynasty antiques worth over £3 million. And actually, when they were found guilty of the offence of plotting to kill Paul Allen, Detective Superintendent Matt Webb from Scotland Yard had said this attack may look like a plot from a Hollywood blockbuster, but the reality is something quite different. This was horrific criminality. But we've heard there from Judge Sarah Whitehouse KC. Louis Ahearne faces 33 years, a 33-year sentence. Stewart Ahearne facing a 30-year sentence, and Daniel Kelly facing 41 years.
All right, Amelia, thank you for that summary for us, that sentencing handed down in the last few minutes. Just a little bit of breaking news to bring you. While I've been talking to Amelia, we understand that the US's Special Envoy Steve Witkoff is currently meeting with the Russian president.